Hello, welcome to the Help with Debt YouTube channel. My name is Steve Thatcher from Help with Debt. Now, today I'm going to be talking about your home and your particular debt solution. So when you're seeking out a debt solution, one key question often posed to an advisor will be, well, what will happen to my house? The effect of any solution taken will differ according to the solution. So here I look at the available options. So firstly, let's deal with bankruptcy. If you own your own home, whether or not that be freehold or leasehold, held jointly or solely, mortgaged or outright, any interest that you have in that property will form part of your bankruptcy estate and will be dealt with by the official receiver or a trustee in bankruptcy. Now, if you have a family home, it is possible to put off any possible sale of that for the first year. This is to advantage. It enables alternative living arrangements to be found, and it provides time for a spouse or a third party to buy out the trustee's share of the property. This is a very common occurrence at times such as this, where many houses have negative equity. I always try to encourage a discussion on transferring the house to a third party if it is still desired to be kept, and I want that done as early as possible in a bankruptcy. If the property is jointly mortgaged, the trustee has the right to realise the bankruptcy interest. A partner is often approached by the trustee to see if the share can be bought out. Now, if no offer is forthcoming, the trustee is unable to sell the bankrupt's share in the property, he can secure his interest by registering a charging order. Essentially, this means that when the property is eventually sold, the share of the property secured by the charging order and any increase in value is paid to the trustee. This will be the case even if the bankrupt has been discharged from bankruptcy. If after 3 years the trustee has either not sold the interest, obtained a charge over the property, or applied for possession, then interest in the property must be returned to the bankrupt. In real terms, this will not happen, as the trustee will always take steps to secure his asset, this asset for the creditors within the 3-year period. Now, if you're looking at an IVA, you're not forced to sell your house, but you may be asked to release the equity built up in it after a certain period of time. So this will be done by either a remortgage, which may now be impossible due to the economic climate, or by way of a further contribution into your IVA for an additional 12 months. If there's no equity in the property at the time of the arrangement, then it's likely to be a condition of the arrangement that the property is revalued in the final year, and then 85% of that increase in value be paid by way of remortgage or, as we said, likely further contributions. And finally, if you're in a debt management plan, then you'll probably be aware that a debt management plan is designed for unsecured debts and so will not include mortgage payments or those on a secured loan. The debt management plan will take into account the affordable income, and this will hence include your mortgage payments. You should be able to meet the amounts due under the debt management plan, and if your mortgage is included correctly. Remember though that the debt management plan is not binding on your creditors, so that if there is equity in the property, this would not stop a creditor from taking action to secure their debt.